Your patent sucks because what's new is not commercially valuable. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. I will probably deliver this message in a number of different ways in the hopes that one of them lands. For this video, I want to convey the concept that one reason a patent sucks is because what is new, and in patent speak, we say novel and non-obvious. What is new is not commercially valuable. I'm telling you this so that you start to learn to link the novelty and non-obviousness of what you have developed with the economic results you are trying to achieve, because I have clients who over and over again disconnect those two things. They think that the novelty and the non-obviousness are just some sort of formal ministerial requirements that the patent office has to issue a patent, which then gives you some broader rights to go knock your competitors out. And that's not at all how it works. The scope of your patent protection will never be greater than what is novel and non-obvious about what you have developed. That is the outer limit of the claims, or the valid claims you can hope to get. Sometimes invalid claims get through the patent office. That's a different topic. But assuming the examination process works as intended, the scope of your protection will never be greater than what is novel and non-obvious about what you have developed. And sometimes it's multiple things. Don't get me wrong. Sometimes you come up with a product and there might be multiple things that are novel and non-obvious, so you have different scopes. But the point is that once you see what is novel and non-obvious, you have to ask yourself, can someone make a highly competitive product, one that's highly competitive with your product, and avoid using what is novel and non-obvious? If they can do that, we call that designing around or avoiding your patent. If someone can produce a product, this is assuming you're going to patent for purposes of market share and because you have a patented product and you want to block out competitors. Okay, so, but if you have a patented product, but your patent's novel and non-obvious features are not critical to the value of that product, that means people can make a competitive product without infringing your patent, which means you can't stop them from doing that with your patent. So like I said, I will try to sort of put this in a number of different ways. Now, I'll do a more in-depth video on novelty and non-obviousness, but basically novelty means there's no single piece of prior art that discloses all the features of what's in your claim. Novelty is assessed on a claim-by-claim basis, so is obviousness. Obviousness means that there was no motivation or design incentive that would have led a person of ordinary skill in the art to either modify the prior art or combine prior art references in a manner that would have led to what you are claiming. So that's novelty and non-obviousness. They are not the only requirements for patentability, but they're the two big ones that you'll see once you get into this. The other ones don't come up as much when you're trying to get the patent. Sometimes they come up more in litigation. Okay, so how does this play out? Well, if you do a patent search, the search results, if it's a good search, will give you an idea of what is likely to be novel and non-obvious about what you have developed. One problem people have with prior art searches is they treat them as a binary thing. Patentable, not patentable. But that misses the boat entirely, because patentable, not patentable, that's a decision you can only make once you've framed a claim a certain way and you can see, yes, is that patentable or not patentable. But the more important aspect of a prior art search is to say what is potentially patentable here. And then once you see the universe of things in what you've developed that are potentially patentable, now you, and it's really not your lawyer, it's you're the one who's going to know the market, not your lawyer. You have to think about those potentially patentable things and ask yourself, how well could somebody do without them? If they don't do these things, will I crush them in the marketplace because I can do these things and they can't? So start connecting the novelty and non-obviousness of what you've developed with the commercial goal you have and see if it's going to get you where you want to go. Because, if you do a search, for example, and it turns out that there's something patentable, but it's an incredibly narrow feature that's easy to avoid, then it's probably not worth the money to get a patent unless you're just doing it for marketing purposes so that you can say that your product is, quote, patented. But you won't have any real enforcement against anybody, and you won't have any real exclusivity because it's a narrow feature that's easy to design. Okay? So anyway, I hope that helps to keep you out of trouble, and I hope to see you here soon.